What we're going to talk about today is foundational estate planning, as it says on the screen. And foundational, my goal for you today is, if you're new to estate planning, once you leave here and after I finish speaking, I want you to have a sense of what are the core documents one needs for an estate plan. What is going to make you feel secure that you're able to have an estate plan where your loved ones know what you want to do with your property, that your finances are taken care of while you're alive. You have someone to manage that. You have someone to back you up with your medical decisions, that you have a will or trust in place, and you have good record keeping. And so what I created was, your estate planning house. So I don't know, how many homeowners we have in here? Homeowners, okay? All right, a number of you, right? Now, whether you're a homeowner or not, right, you want your house in order, right? Everyone wants a clean house, organized house. It just, it helps when your surroundings are organized and clean, right? And the same with estate planning, you want to have some order. And so there's a lot of things that people don't realize how estate planning works together, right? There's documents that you really want to start out as foundational, and you build upon that like a house. A house with a poor foundation, what will happen to it? Fall down. I'm sorry, I don't make this interactive, so I'm not just speaking, right? It's going to fall down, right? So if we have the next slide, please. Okay, just a little disclaimer. Have to do as an attorney. So this is the information shared in this presentation, right? Does not constitute legal advice. Of course, I have to be careful and to protect the public and myself. This is just legal information, right, that I'm sharing with you. Every situation is different. That's one of many important things to know about estate planning, is that your situation is particular. No one is like you. Some are similar, but every estate plan is different. Every situation is different. Everybody's different. Okay, so if you need a specific consultation, please consult an attorney who's practices area for that. If we have the next slide, please. So a little bit of overview, more specifically, we're going to talk about today. I want to go over the benefits of estate planning, as Manny touched upon in his introduction. Your estate planning house, which I talked about. We're going to talk about healthcare proxies, living wills, and the Family Healthcare Surrogates Act. Now, what is that? We'll get into that. We're going to talk about power of attorneys and guardianships, wills and trust a little bit, and the importance of record keeping. So I see someone taking pictures. Yeah, go ahead. Make sure you get that. I'll see if I can also share the presentation at a later date to the staff of Mr. Levine. So if we can have the next slide, please. Okay, so some benefits of estate planning. Whoop. So as you can see here, one is having an estate plan reduces stress in your loved ones, because they'll know, how to honor your wishes, right? And what's important about this is that, and I want to leave you here with, and I hope you were able to pay attention to the prior slide, that the overview, right? There's one thing I want you to remember as you go on through this presentation. If you don't have an estate plan, does anybody know what happens? What if you don't have it, you die, don't have an estate plan? How do we know how to handle your estate? Anybody? All right, I heard of mutterings about one at a time. You can raise your hands right here. The state of government gets involved. That's right. Anyone else? Goes into probate. What do you mean by that? Okay, that's true. Right. So we're going to get into that. Probate is Latin for prove. That means prove a will, to make sure it was done properly. But if you don't have an estate plan, the state makes a plan for you, right? And the courts will get involved. And when you don't have an estate plan, that's called dying intestate, is without an estate. Okay, so really that's actually outside of probate, because probate means to prove a will. So we'll get back to that. But that's one thing, is that you don't want, when we pass away, we don't want our relatives stressed out, right? I'm sure you have encountered it with some of your relatives that passed on, and in your life. I've seen situations where people are fighting, are stressed out, and sometimes it's just over what did mom or dad want, or my cousin, whoever, which your loved ones unfortunately passed away, it just makes things easier. The second thing is you want to have an estate plan, you want to share and have it written down, right, not just a piece of paper, but in a bona fide legal document of how you want your assets distributed. Because if you don't, the government has that plan for you. And guess what? The plan that they have for you isn't necessarily what you want, right? And so what would you rather have? Do you want to have a plan to administer your estate and a plan of the distribution of your estate according to what New York says or what you say? What do y'all think? What's the preference here? How many want what you say? Right, not the state, right? And so that's what happens. That's really basically it. It's that simple, right? And you know, and so as one person made a comment, if you don't have an estate plan and there's nobody left in your family that's a next of kin, like if your spouse passed away, you have no kids, and the further along your descendants, the distance of your descendants that have survived you are too distant, then it will go to the state, right? That money will go to the estate in your estate that you left if you don't have an estate plan. The third thing, estate plan is playing good defense, right? I don't know if we have any sports fans in here, but you know, it's not just good offense of making the estate plan. That's affirmative, that's doing something, but you're also playing good defense, right? Because if you don't have an estate plan, especially those foundational documents we'll get into, right, you're vulnerable. And you're vulnerable to what? Guardianship. Now, when I see the word guardian, I also practice in that area, by the way. When I see the word guardian to some of my clients, they cringe. People think that it's a bad thing. I'm not saying guardianship is a bad thing, but it's a very invasive thing. Now, I don't know if everybody's familiar with an Article 81 guardian. Is anyone familiar with guardianship and how that works in New York? So I get a sense of the room. Okay, I see one back there. So guardianship, we'll get into it, but that's when someone is appointed by the court to manage your personal and property. And I am a guardian right now. I have been a guardian two prior times, or I'm a current guardian to my wards. That means a person that I am guardian over have passed away. But it can be very invasive, right? And as we get older, even when we're younger, you know, you could need a guardian because unfortunately you have a disease or a mental infirmity, something where basically it has to be proven in court that you can't manage your personal affairs or your finances. You could get a guardian appointed over you based on a petition submitted to the court, right? But it's very invasive. And as we get older or in any time in our life, no one wants to lose their independence, right? And so but if you have a good estate plan with good foundational documents, we can avoid all that. Now, if we have the next slide, please. Okay, here we go. Now, this is our estate planning house, okay? You want a house with a strong foundation. And at the bottom, if you can go back again. I don't know if it's automatic. Thank you. On the bottom, we have a living will, healthcare proxy, power of attorney. That's like our foundation, right? Built upon that is a will or trust. And then, I think it might be automatic. And then, thank you. And on top is, in the attic, we have, a lot of people store things in the attic, right? Funeral information and family history. That's basic estate planning house. If you have those things set up, you'll be in good shape. Go to the next slide, please. All right, healthcare proxy. How many people know what a healthcare proxy is or have one if you don't mind sharing? Healthcare proxy. Okay, we have a few. Okay, well, a number of you. Good. So a healthcare proxy will be the next slide. A healthcare proxy. Let me see if I can bring it up here. Okay, so the healthcare proxy is basically a document where you appoint someone to make medical decisions on your behalf, okay? And obviously you want to appoint someone you trust, someone that knows you well. Also maybe someone that knows your religious affiliation, right? Because a lot of times, whatever your faith is affects what kind of medical decisions that you would make if you had capacity at that time, right? Now, a healthcare proxy, okay, has two major roles, right? The person that wants the healthcare proxy is the subject of the healthcare proxy is the principal. That's you and me, right? We want a healthcare proxy. The person that's going to make the decision for us is the agent. So those are the two main roles, right? Now, the agent can only act when what occurs? When we become incapacitated, unable to make medical decisions. Now, That incapacity doesn't mean like incapacitated forever. You know, some people are in that position, unfortunately, where they may have a certain mental illness and they're deemed legally incapacitated, or they're just not able, they're not aware anymore of and don't have the ability to make medical decisions, the best medical decisions in their best interest. Now, but it can also apply in a short-term situation. So in other words, let's say that I go get surgery and I have anesthesia and something goes wrong in that time period, right? I'm not permanently incapacitated, but for the moment I am. Guess what happens? If I have a healthcare proxy, the doctor would, have that or call that person up and say, okay, this is what's happening with Keith. They would make that decision, interject the best decision based on they know of what I would want on my behalf. Now, of course, it is wise to not just appoint a proxy that you know, that knows you well, but a backup. In any estate document you do, you always want to have a substitute, a backup. We never know what may happen. Your agent that you appoint may pass away, may not want to do it anymore. Anything could happen. So in the healthcare proxy, you appoint one agent, and it's always good to appoint a substitute. And you only have one healthcare proxy at a time, okay? Now, 2 witnesses are needed to see you sign a healthcare proxy. You should give a copy to your primary doctor. There's also now organizations and companies where you can upload the document, they'll store it for you, and then you give your doctors, or at least give it to your primary doctor, I would say all your doctors, you can have him or her have a password to the site, and they can just upload or download it to their business and their files, okay? In the healthcare proxy, and I'm sure some of you are familiar, especially you that have it, you can also insert your wishes about what you would like done, what kind of medical decisions you would like to be made, like do not resuscitate, similar to a DNR, a do not resuscitate form, whether you want a feeding tube, in the healthcare proxy, okay? If we get the next slide, please. All right, a living will. Now, this is a little bit tricky, okay? So here's a first test here. First of all, how many people know what a living will is? Anybody, living will, familiar? I see a few hands, okay. I don't know if anybody feel comfortable, those who raise your hand, do you mind, if you're comfortable stating what that is? What do you think it is? Anybody? No? Okay. Is it the same as a last will and testament? No, okay. Some people do get that confused, understandably, because it says will, right? But a living will is just basically a document stating what kind of medical decisions you want made if you're, and this is the key point, if you're in a situation where you have a terminal illness, right? And only God knows if the illness is going to be terminal, right? We don't know the date or time of when we'll pass away, but the distinction between a healthcare proxy, it's important to understand, is that a living will is really activated when a doctor or physician has told you that you only have a certain amount of time to live, as opposed to a healthcare proxy we just talked about, that can kick in and apply when I'm just temporarily incapacitated. Maybe I'm in a surgery, I have anesthesia, different examples like that. So that's how you can distinguish it when it will come into effect, when it can be used, right? If we have the next slide, please. So, like I said, it's often confused the last will and testament, where in that last will and testament, you're talking about how your property will be distributed when you die, right? But living will, we're talking about the medical wishes, again, in the event that we're in a situation where we have a terminal illness, right? Or a doctor has deemed that when a terminal illness, and we can't make medical decisions. So a living will and a healthcare proxy, right, we conclude they go hand in hand, like the yin and the yang, right? Like a dynamic duo. You shouldn't have one without the other. Because if you think about it, if you have your healthcare agent, especially those you have one, I would strongly consider you making a living will if you have a healthcare proxy, because now your agent, suppose something happens to you, how would they know what you want? Now you might say, well, Keith, my agent knows me well. They know what I want. And that's fine, you could do that, but I think it's always better to have something written down, right? It's always better to have that living will in conjunction with the healthcare proxy, so as an agent, they know what to do in every situation. Now, None of us are God. None of us can foresee all the situations. But we want to make a comprehensive living will as, we want to make it as inclusive, as comprehensive as we can to cover as much situations as we can. But that's a help to your agent. We want to help and not hinder those who are, making decisions on our behalf. Okay? If we get the next slide. I think we'll hold questions to the end. There's a Q&A. We're going to have a Q&A time. If you hold questions to the end, I think that'll be easier, and I'll be glad to answer them. I appreciate that. I think it'll just be easier. We'll continue on this. So a living will, some of the many things it can do, it can direct whether life-sustaining procedures should be implemented or not, right? To your choosing, whether when you have a terminal illness or do not reasonably expected to survive. Now, some examples of this, I think I mentioned one, is surgery, right? Whether you want surgery or not, respiratory support, artificial nutrition, hydration, that's the fancy way of saying feeding tube, even antibiotics, et cetera. Pretty much any kind of affirmative medical remedy or solution, you could say, I want that, I do not want that in the event that I have a terminal illness. If we have the next slide, please. Okay, so now we're at the first kind of road mark here. Now, a few minutes ago I just said, the goal of this presentation, outside those first main points, is I want to show you two directions, right? We're forking the road. What happens when you do an estate plan? What happens when you don't? So we touched upon that. So far we talked about healthcare proxy and living will. Well, so you say, Keith, what happened if I don't? Well, the state has a plan for you again. It's called the Family Healthcare Decisions Act, okay? And the Family Healthcare Decisions Act basically says that if one doesn't have a healthcare proxy, well, we have an order of priority of people in your life that start out with your next of kin, your family, that will make decisions for you, right? So many of you, I'm sure a lot of us may have had loved ones in the hospital, maybe have not had a healthcare proxy, and who does a doctor talk to? What is the first thing they ask? If your loved one can make a medical decision, they say, well, are you married? Is your son here? And they talk to that person. That's why they do that, right? Because the state, not everybody's going to have this document, so the state wants to make provisions for you, right? And so, if we can go back to that slide, I'm sorry. Real quick. So the key to knowing when this applies is this act applies and allows family members to make decisions, or even friends in some instances, for patients who lose their ability to make such decisions, right? So if you have the abilities, it doesn't apply, right? You'll need a healthcare proxy or anything. You have to lose your ability to make decisions, and you haven't put an advance directive, that's another term for healthcare proxy, in place. We get the next slide, please. Okay, so this is a priority, right? Now, I want you to look at this because it's kind of interesting. It starts out with the next of kin, but what do we see on the first one there? What does that say? The first order of priority, the first person in charge. Court-appointed guardian. So now the guardian has inserted his or herself in the picture, right? Why are they in the picture? Why is that first? I imagine because when the legislators wrote the statute, they said, well, not everybody has things in place. So again, I keep reverberating this theme. If you don't have something in place, you could have a guardian appointed over you, and that guardian will have the power to act as a healthcare proxy automatically under the law based on what a guardian can do. That's why it's first. Then we see the spouse or domestic partner. Then after that, it's order of priority, child of 18 years of age, got to be an adult. Then the parent, if they're surviving, a sibling. And lastly, a close adult or friend familiar with the person's religious and moral views regarding health care. Again, that theme comes up. You want a person, if it's a friend, that knows you well, right? So that makes sense. If we have the next slide, please. All right, power of attorney. Now, this is one of the most popular documents I think I'm asked about out of the three, right, and probably the most comprehensive. Now, who in the audience is familiar with the power of attorney or has one if you're comfortable sharing? I see a few in the back. Okay. If someone wants to answer, what would you say a power of attorney, what does it do? What is it for? Deal with your documents, okay. Does it have to be an attorney, you think, or no? In the front here? Right, take care of your business. And is it dealing with medical or is it financial? What do you think? It's actually financial. It's related to medical in terms of bills, but it's really a financial document. The medical will be more the healthcare proxy or living will, right? But it would, as a power of attorney or as an agent under power of attorney, you'd want to have access to someone's bills, so you might have to have them sign the HIPAA release form. But it's really a financial document, a very broad one. If you have the next slide, please. Okay, so the roles of a power of attorney, and some of you, if you have one, you're definitely familiar. So the power of attorney is a document, again, that grants the authority to someone, doesn't have to be an attorney like we said, to manage your finances. It's very broad. There's about 15 categories of different powers a power of attorney could have if you grant them those powers. So the roles is a principal, that's you. You're the subject, you're the power of attorney, you're the person that wants it, okay? Let's see where we at. Then there's the agent, is the person that is actually your power of attorney or your person that manages things for you, okay? And you want to, it's important, again, with all these documents, a running theme is that appoint someone that you trust. I mean, that's kind of obvious, but you'd be amazed at somehow how many times people appoint somebody and people really use this as a way to be unscrupulous with other people's money and get in their finances and, steal from them, right? I had a guardianship case one time where the whole reason for the guardianship was, guess what, that the person appointed someone as a power of attorney. The person was very aware. I was an investigator. I evaluated them. And her power of attorney ended up stealing her money. And APS got involved. They caught it, brought a guardianship petition. And had they not done that, this person would have had a windfall. She was buying stuff from Macy's, retail. She's having a good old time. But thank God we stopped her, right? And so you got to be very careful who you trust, right? You got to be very careful. Next slide, please. Now, what I also want to do for you today, especially, but for those who have one too, is, and it'll be a reminder for you, is this, just to give you the roles and this kind of the basic structure of a document, right? Because that way when you go to attorney, you say, I went to a estate planning presentation, and when that attorney starts, giving that legal jargon, you're somewhat familiar, right? So the first main part of a power of attorney is a designation of agent. It's going to be the agent's name, their phone number, their contact, in case they need to be reached. That's the first part of a power of attorney. And also, obviously, you're the principal, you have your name and address on there. The next is the grant of authority. Now, there's 15 sections of powers in the power of attorney. There's power to handle taxes, real estate, goods and chattel, to sell things, power to pay medical bills, power to sell your real estate. There's so much more power to give gifts, right? And the power to give gifts is really defined differently in the legal world, not just like a birthday gift or birthday present, but actually power to transfer money, transfer your property. So power of attorney is very, it gives a lot of authority. But the great thing about it is the law gives you options. You don't have to give anyone all the powers if you don't want to, right? The next thing is the grant of gift transactions. Now, the power of attorney law has changed. I'm about to get into that. But a basic power of attorney, unless you specifically authorize it, will only allow your agent to transfer $5,000 or less. If they transfer more than that, they can get in trouble under the law and be taken to court and suffer penalties or civil penalties, right? That's for your protection of you, the public, right? Because what I just said in my example, people unfortunately are not of so much integrity and they take advantage, right? So we want to make sure that that was something you or we consented to, okay? The next section is the modification section, right? In this power of attorney, the way the legislators drafted it, like I said, it gives a lot of power, but it doesn't give you everything. For instance, how many of us use online banking or have online management of our accounts, right? So I'd say about a third of us, right? Or maybe a lot of us. A power of attorney doesn't automatically have the ability to access your phone. God forbid they need to get into your documents. That would be something that you have to add to it. So for those who don't have a power of attorney yet, or maybe you do have one, I would have an attorney check it over, because the way I do my power of attorneys are very comprehensive. There's a lot of information in there, a lot of additional modifications, just in case something happens. Okay, we want to be comprehensive and thorough. So some of the classic modifications, some people select a guardian in the power of attorney. That way, if a petition is brought against them, at least the court knows who you'd want to be guardian. Maybe ability for the agent to access your phone. Access to change beneficiaries and life insurance policy. It's something people wouldn't think about. That's not automatically given under the statute. And the last section is appointment of a monitor. And a lot of these financial documents, especially, or in a guardianship, there's someone that, in a power of attorney is optional, you can ask someone to monitor or watch over your agent, just to make sure they're doing things right. And that monitor would ask them to submit financial records, documents, stating what they've done on your behalf, and it's supposed to be for your best interest. If we can, next slide, please. Now, the power of attorney is under a new law, and new as in it was, came into legislation June 13th, 2021. So it's not really so new. It's 3 years old, but became effective, and it made substantial changes to make it easier for people to get a power of attorney. Before this, I don't know if anybody experienced this with a bank. Sometimes banks are not so easy, right? They can give you a hard time. And they would reject the power of attorneys, believe it or not. They would say, this language is specific enough to give people a hard time, but it hindered people who really needed help. And so the legislatures got together and said, we're going to make the form easier. But what they did to address that bank issue, they say, if a bank unreasonably withholds your ability for your agent to use a power of attorney, they can suffer penalties. So that was a great addition to that. Some other changes is that sometimes the bank or other institutions will reject it. They say, that the statute would have said you have to write certain parts of the power of attorney exactly the way the statute is written, in terms of the description of what the power of attorney is about. Now we have to just substantially conform. As long as we get in your power of attorney the essence of what it's about. It doesn't have to be exactly what the statute says. The power of attorney is fine, right? One of the last, and not all the changes, but I want to highlight, is now a third party can assist the principal, meaning us, to sign the power of attorney. One time, several years ago, when I worked at a firm, the client asked me to go do a power of attorney for the father. So I went down to Brooklyn. We had brought the pre-drafted power of attorney. And what do you think happened when he tried to sign it? Anyone want to guess? He tried to sign it, and what happened? What do you think? Take a guess. He what? He couldn't sign, right? He wasn't able to sign. This law wasn't in effect yet. This is about 2018, 2019. If I had tried to coerce him to sign it, force his hand, I could be liable, right? Because it looks like, well, was that really his consent? See, these are the things that we have to be very careful with. But now with the new law, as long as the person has capacity, you always need capacity to sign a legal document, right? That's presumed, or that is required. He can ask me to sign that. So if the new law was in effect back then, no problem. I've signed it for him. I had his daughter sign it for him. As long as the person who signed it is not a witness, right, to the power of attorney. I'll feel the next slide, please. Okay, other highlights about the power of attorney. So one we see here is that there can be more than one agent, right? There can be more than one. Now, some of you may be thinking, you got to be careful with just picking one. So you pick two, you want to make sure they can work together, right? You don't want your agents fighting, anything going on like that. That would just hinder the ability to get things done for yourself. And it's important to note also, too, that a power of attorney, when do you think a power of attorney be able to be used? What does everybody think? At what time point? To do anything? Okay, so I got one answer that says a power of attorney can be used by the agent when someone's not able to do anything. So that is true, but can someone, as an agent on your power of attorney, help you out while you do have capacity, once it's signed? Who says yes? Yes, that's right. So power of attorney is therefore called durable. It's called durable because you don't have to wait till you're incapacitated for your agent to act. I was a power of attorney for my father before he died. I acted as soon as he signed that, right? Because he just wasn't able to travel and do things like he used to. And that's the great thing about it. So it's really a great tool if you have someone that you can trust, because suppose you become disabled, you just can't go to the bank. You have your full faculties, but it's your power of attorney can go there for you. Take care of your bills, take care of business, right? Like the healthcare proxy, probably even more so, or just as important, have a successor agent. I would recommend a backup. A power of attorney sometimes can be a lot of work, right? And side note, you can have on your power of attorney, according to terms that you make, have them paid, compensated. It should be written in the document. But it can be a lot of work depending on the person's abilities or lack of ability to manage their finances. You want to have a substitute. Maybe a person unfortunately passes away as an agent. They're not available anymore. But it's always good to have a backup. And then lastly, just for your own edification, for the document to be valid, the principal must sign in front of a notary. The principal, you have to sign, sign in front of a notary, right? That's the only signature to be notarized. And then 2 people must witness this signature. And then the agency also has to be notarized. But your signature is only signature has to be witnessed. I apologize. Both the signature of you and your power of attorney or your power of attorneys, your agents, have to be notarized as well. For the next slide, please. All right, we have arrived to the world of guardianship. Now, guardianship, like I said, it's very invasive. It is something that's prevalent in New York City, New York State. I serve various roles in the guardianship proceedings as court investigator, attorney for the person who is alleged to need a guardian. I've represented people who want to get a guardian over a family member. I've been in all different roles. It can be very emotional, as you can understand, very tough. We have the next slide, please. So guardianship is a process, again, where a person, it could be individual, usually someone's next of kin, spouse, children, concerned friend, even an organization. Pretty much anybody, as some of my judges say, can file and ask for a guardian to be appointed over you, right? And that's under Mental Hygiene Law, Article 81. That's the statutory provision that allows this and dictate the laws of guardianship, okay? And there's 2 things that they're alleging that you can't do. Manage your personal needs. That's your ability to walk, eat, dress yourself, go to the doctor, cook, go shopping, all your personal needs. All that's under your personal needs, making medical decisions, things like that. And manage your finances. Any aspect of your finances you can think of, they're alleging this petition, and they have to present proof and present testimony in court that you can't do that, okay? And 2 main questions need to be answered in the guardianship hearing. Does a person who's subject of this case need a guardian, right? Just because I make a petition doesn't mean, and say you need a guardian, doesn't mean you really need one. You'd be surprised, these cases are a little bit tricky. A lot of gray areas there, right? Every scenario is different. And then the second question the court's gonna ask, if you can prove a guardian is needed, or who should be the guardian, right? And you'd be surprised, maybe not surprised, how many family members go back and forth and kind of sometimes fight over, who should be the guardian of mom or dad or the brother or sister, whoever is involved in the subject of the case. For the next slide, please. Now, just some of the main roles in the guardianship, just so, for your own edification and familiarity, the first and main person is the subject of the proceeding is called the AIP. So some guardianship lingo for you. That's the alleged incapacitated person, the person who's alleged to need a guardian, right? The second one is the attorney for the AIP. That could be me, where I'm a person who represents and advocates for the AIP. Often, what do you think? Do you think that most people in these cases, the AIP I'm talking about, how many people think in most cases they'd want a guardian? What do you think? I'm hearing probably not. You're probably, and you are right. Most cases, people don't want a guardian, right? Now again, I'm not knocking guardianship. It can be a great thing. When you have a person that really cares, you have family members doing a great job, The courts want that, and the courts encourage family members to be guardian, but most people, they're just resistant, whether it's pride and they don't want to admit that they need help, or whether it's just, this is very invasive. It's like you used to, think about it, you've run things your whole life, and someone comes in like me, hey, I'm going to handle your finances for you. How would you feel? It's a lot. It's a lot. Next is the court evaluator, The court-appointed investigator who interviews the AIP, alleged incapacitated person, his family, medical professionals if in their facility, or talks to their doctors. And the main job of the court investigator, or the formal name is court evaluator, they're going to make a recommendation to the court. So as a court evaluator, I'm the eyes and ears of the court, right? The judge can't go around, obviously for obvious reasons, to ascertain if this is the appropriate remedy for this person like yourself or myself to get a guardian. So I'm sent out to investigate. That court advisor is going to investigate and write a report for the judge. And that weighs heavily on whether there's a guardianship or not. Okay, and then obviously a guardian is a person, or sometimes a nonprofit organization does this as a business, appointed by the court to handle the personal needs and or finances of the alleged incapacitated person if they are appointed a guardian. Next slide, please. Now, there's some pitfalls to guardianship. There are many pitfalls to guardianship. Oh, am I in the way? One is a guardian, as we said, a guardian has more statutory power in New York than a power of attorney, right? So for all those who have a power of attorney, you know how much power you have given and trusted to your person or your people, right? But imagine someone coming into your life that you didn't even want, saying, I have more power than that. I'm your healthcare proxy. I'm managing your finances. Just recently I was guardian for a 94-year-old bishop. He was stubborn, didn't like me, didn't like anybody handling his money. He'd often yell at me, where's my money? And I said, sir, it's in the guardianship accounts right here. But it was a fight for like 3 years, and I had to do things because this guy had millions of dollars in properties, 4 properties, real estate rich. What wasn't taken care of properly, right? As a guardian, I can't just sit here because he doesn't like it. I got to do the right thing and take care of it. So some of these situations aren't easy, right? But it's very invasive power, right? A lot of power. Now, once a judge signs the order show cause and petition asking for someone to get a guardian over them, this case is coming back to court in only 28 days. 28 days. Guardianship are called summary proceedings, meaning they're supposed to go quick. Now, anyone who's been involved in the New York court system, usually it's not quick, but it's my experience at least. But that's the goal, is that because these are urgent situations, it's like landlord-tenant, also supposed to be summary proceedings. But sometimes those cases can go on for a couple of years for different reasons. But the idea is that these situations are urgent, and so you want to take care of them quickly. Now here's the kicker, right? Someone comes in like me and says, you know what, I'm in charge of your person and property. I'm sorry, sir or ma'am, you didn't want it. That's bad. The court have appointed me, right? It's not my fault. I'm here as an officer of the court appointed. I'm really sorry that you don't like me, but I have to do what I have to do. And guess what? Court appointees like me, as a court investigator, I'm appointed by the court. This is not something that I solicit. It's statutory. Sometimes the attorneys for the AIP is appointed by the court. AIP could hire their own attorney, but there's a tricky question. How can a person that may be incapacitated know enough to hire an attorney? Makes you think, right? But if you're court appointed, guess what? Now you have a guardian, possible guardianship or guardian appointed over you, but then the court, if the court thinks the petitioner, person asking a guardianship appointed over you, is right, and they win the case, myself or other court-appointed individuals get paid from your estate. You got to pay for it. A lot of people don't like that. Now, you may think, Keith, that's unfair, and you're probably right. But that is the law, right? The rationale, what do you think the rationale behind that might be? Anybody? No, I've said that. Why would the court have the AIP, alleged incapacitated person, if they get a guardian granted to manage their affairs and their personal needs, have them pay for it, assuming they have the money, of course. Why would they do that? Doesn't sound right. I'm doing work. Okay, that's true. What, anybody else? Who's paying for a service? But why do you think the law makes them pay for it? And we had one right answer here is because people have worked, but why should they pay for it if they didn't want it? Right. So it's basically it's a benefit to the AIP. So the rationale is whether you want it or not, people have worked for your benefit and they should get paid, right? And so that's why that happens. Via the next slide, please. All right, so this is probably the most familiar document, I think, that everybody, if you talk about estate planning, I think most people, everybody likes Family Feud here. I do watch Steve Harvey in Family Feud. I think if you ask that question, what's the most familiar estate planning document? You know, they do that survey thing at the end. What is that called? I don't know what that is. I guarantee you 95% of people in America would say a will. Like most people are familiar with a will, right? And the proper name is last will and testament because you can do many wills, but it's your last will that counts, right? If the next slide, please. Okay. Oh, man, I didn't want to go there yet, but anyway. All right, so what property does a will cover? It covers property, only property that was in the decedent's name. Decedent means the person who made the will and has passed away, whether it's you or me, or whoever is subject of the will. Anything that was in your name when you pass away. So, joint accounts, are they applicable to a will? What was that? Somebody, I said muttering, no, right? Accounts payable on death, bank accounts of the beneficiary, is that in a will? No, right? Because all those accounts, whether it's joint, the other joint owner would get the account. If it has a beneficiary, that's what they call non-probate assets. It's you already provided for someone to take over those funds, right? So no joint accounts, retirement accounts of beneficiaries, life insurance policies. I had a constituent, did a will for her just in nick of time. I mean, she's all right, but before the program ended for the summer, and when we were starting to do the consult, she said, can I put my life insurance, amount of my life insurance in there? I said, no, for policy reasons, we can't do that. That whatever beneficiary you have in that policy, they will get the money, and they do, hopefully do the right thing and, pay for what needs to get paid for, but that's how that works. That's for policy reasons. Can we have the next slide, please? Okay. Just like I did with the power of attorney, let me get out of the way for the pictures. I want to give you a basic structure of a will, right? So that when you go home, you can say, okay, for those who don't have a will, when an attorney presents you with one, or you may do LegalZoom, there's probably other companies out there, you kind of familiarity with what should be in a will, right? In a simple will, which Manny talked about. These are the basic things. And fancy mumbo jumbo exordium, that's basically introduction. You want to have a basic introduction. Who are you? Who is the subject of this will? You want to state things, your address, you're a citizen, you're over 18, you can do this will, things like that. And that's your last will and testament, right? Keyword last, because you could have prior wills that if you make another will, the most recent will would revoke the prior will, right? That's the exordium. Disposition of property. You could have, so property means a lot in the law, right? Not just physical property. It could mean your valuables, your jewelry. It could mean your real property. It could mean your condo, your co-op, your cash, your bank accounts. Okay? Does anyone know, let me ask you a little question. A co-op, we have any co-op owners here? Co-op. Okay, I see a few. So I know you'll definitely know this. Is a co-op real property or personal property? That sounds kind of like a question. I had one person. Anyone else? What do you think? Personal, real? Personal, it's personal property, right? Because you as co-op owners out there own a share of a corporation manifested in an apartment, in a co-op, right? Which can be put in a will, but that's important because it has to be, and a will is kind of broad, but if you want a good will should, if you're co-op owner or real property, should denote and define where that is. Where is the co-op located? I would put the certificate number, how many shares. If you are a homeowner, put in obviously the address, okay? A lot of people in New York City, co-own either the co-op or the real estate. Well, you might want to put, how much percentage of the home do you own? So I bequeath my 50% share of my house. Because if you're not owner of a home as a joint with right of survivorship and you die, you only can give what you have in life, right? So if you own 50% of the house or a third of the house, maybe you own as a family, then when you die in a will, you only can give that third away. You can't give what you don't own, right? Next is the tax apportionment clause. That's just basically most people write. It's how estate taxes are handled. Now, estate taxes won't be triggered in New York State until you reach about 11 million. So a lot of people are they'll have those size of the estate, so that shouldn't be an issue. But in case something comes up, most people just say any taxes will be burdened on the expenses of my estate. Expenses come out first. When you're probating a will, we take care of expenses first, then we make the distributions to our beneficiaries if we gave people things, right? Now, how many cooks we have in here? Who likes to cook besides me? Any cook chefs in here? I see a gentleman over here. I see some ladies back there. Anybody else? A few people over here. Now, the tangible property, your autograph photo of Michael Jackson, your autograph baseball, all that stuff, you want to give that to a person specifically, right? It's just better to do that. Any highly valuables should be specifically designated in the will, right? So people ain't not fighting over that when you die, right? But when you think about property, tangible, real estate, cash, what am I missing? Other personal, probably bank accounts. That is the meat of your estate. That's the meat and potatoes for us meat eaters. If you're vegan, maybe some lentils, I don't know. If you're plant-based, right? But that's the meat of the meal. You think about the meat of your estate. The fourth main part of a structured will is residuary, the leftovers. So I don't know if anybody eats leftovers. It's too much to cook every night. I do the leftover thing. It's any cash or property that has not been designated to someone. Sometimes a gift, what they call lapses in a will. So I say in my will says I bequeath my Tom Brady rookie card to my brother, Andrew, and then my brother passes away before me. That gift will lapse, right? And so we'll go into the leftover abyss, right? And so that's what residuary means, the leftovers. What I'd recommend to kind of remind yourself, I see people taking notes, in the residuary clause first of all, if you have a beneficiary in a will, that means a person is receiving a gift, have an alternate. So if my brother Andy dies before me, then my friend Barry will get that Tom Brady rookie card, right? Lucky him, right? That way you're provided for. But in case, what if you say, Keith, what if something happens to both of them, so some crazy, accident, right? Then it will go to the leftovers. Well, then how will it be distributed? I'm going to get into that. It will go based on the laws of intestate, right? So in the will, we try to avoid anything going outside the will, but it's impossible to catch every scenario. Without being God himself, all attorney can do is just try to plan for various scenarios. So when you sit with your attorney, if you do this, you might get annoyed. He might drive you crazy. Like, why do we have to go through all these different logical chains? The attorney's going to say to you, a good attorney will say, just for your protection, just in case. Really, it's for your family's protection, because it just makes it easier to administer the estate. Number 5, appointment of the executor. Again, running theme, healthcare proxy, power of attorney, will appoint someone you can trust, right? An executor is a big job, and guess what? They get paid. They get paid out of your estate if there's money. If there's no money, unfortunately, they can't get paid. But if you have some money left over, the executor gets a commission under the Surrogates Court Procedure Act. They get a percentage, okay? If you say, I want 2 executors, guess what? They'll have to split that fee. And also, if you have a good amount of money, your attorney who probates the will, if you do a will, can get paid out of that too. So a lot of people get paid for your money. So just consider that. Again, that's more for your family to deal with, because they'll be dealing with that, administering that when you plan your will. But the appointment of executor is a key part of the will. And usually the attorney will list the executor, the name, the address, and list the powers under the law. They don't have to. It's in the law already. But a lot of attorneys like to list the powers in the will. And lastly is the kicker, the thing that makes it official. Last sentence of the will, the testimonium, that's the clause that reads, whereof, this is my last will and testament, and you make it official by signing it, okay? For the next slide, please. And we'll touch a little bit about trust. Anybody familiar with trust? Ever done one before? Know what a trust is? All right, I see one here. Can anyone tell me what a trust is, what you think it is, if you're comfortable? What do you think what a trust is? Lady in the front. Okay, yes, that is one form of a trust. Here. Okay. Okay, so trust could definitely do that in front here. How does it control you? Try to get rid of a trust, you mean? Oh, okay, so we have a person with experience here. So she said, if whoever didn't hear, it gives you more control, certain trusts do. And I think you said, correct me if revocable, right. So we have an expert here. Revocable trust will allow you to give you some control, which one trust will do. As a person that makes a trust, you have access to manage in a revocable trust, right? And it is hard to revoke a trust. It can be hard, especially if it's irrevocable. So very good. Next slide, please. Okay. So trust is a estate planning tool basically where a grantor, meaning you or me, whoever wants to trust, transfers property to another entity. The trust is really an entity. So the trust of Keith Barrington Allen, or we talk trust fund babies, the trust and the benefit of, whoever that person is, right? And you're appointing a trustee to manage the assets. The fancy word for assets is corpus. I think it's a Latin term meaning the body, the main, the trust. Sometimes that could be real estate. It could be cash. It's attached to a trust account. So the grantor is a person who wants to make the trust for the assets. Trustee is a person or entity, or sometimes court appointee, can come into charge of a trust who manages the trust assets, pays the bills, collects the income, manages the account, right? The beneficiary is a person or entity, could be a charity, entitled to the assets when the trust is no longer needed, or maybe a beneficiary of that trust that was made for them to help them survive, right? A lot of people who, if you're on Medicaid, for example, someone's on Medicaid, a trust is a popular estate planning tool for how people qualify for Medicaid when they have too much money, okay? Which is the last point there. Next slide, please. Will or trust? What do you think? Will or trust is the question, right? So let's compare and contrast. A will names an executor. A trust names a trustee, okay? The will is of public record. I always say, I can go down to the Surrogate's Court. I'm usually in Queens, so I say Queens. I'm in Manhattan now. Surrogate's Court, Manhattan. Go to the records room. Find your will right now. Couldn't stop me, right? It's of public record. A trust is private. A lot of people like trust for these reasons. They don't want to share their business, and it's to your right. I can understand that. A will is fairly easy to draft. Manny said, we're going to do simple wills sometime in the future. It can get complicated. But the more complicated of an estate you have, the more complicated the will get. But they're fairly easy to draft. How much you think a simple will might cost you? Now, it varies by attorney. Anybody throw out a number? What is it? I heard what's over here? $1,500, okay. How much you hear? $700. Anybody other numbers? That can drive with the price. Yeah, just get a gauge. So I had 15.7. Anybody want to throw out a number? I think a will would cost in New York. Other guesses? Okay, so $700 to $1,500. Again, depending if it's a big firm, they're going to charge you for the name and all these things, right? But somewhere a simple will might at least $7. I think you can get less than that. LegalZoom might be different. I'm talking about from an actual attorney or firm. Probably $700 to $1,500, maybe a little bit higher. like this lady said here, if there's more to do. The more to do, the more work for the attorney, and usually it's flat fee, the higher the price is going to be. So I would just say a simple will is it's pretty clear who your beneficiaries are. There's not a lot of cash gifts or gifts to make. Not a lot of people who don't have a lot of next to kin left. You know, if it's one beneficiary, that makes it easier. A lot of times what drives up the prices, the more beneficiaries, more contingent beneficiaries, more assets. So minimal assets, minimal beneficiaries. I would say that's a simple will. Trust, on the other hand, can be very costly, be drawn up. Need ongoing maintenance, like this lady said here, a revocable trust, right? Ongoing maintenance and time-consuming to establish. You got to interact with a bank again. Banks can be difficult. Anyone have an idea? Throw out a number like the lottery. How much does a trust cost? Trust should run you. $6,000, pretty good. It can get that high. Anything else? Any other guesses? Probably on the higher end, 6,000. Anybody? What do you think? 3, 4? No? Okay, so I would say about 6,000. You're right. 6,000, maybe 5,000. I would say at least 4 to 6. It's going to be probably about twice the amount of a will. It's a lot more work. It's a longer document, more maintenance, especially can get complex. There's various types of trust. We have no the time to get into that. But that's a negative, right? Will and testament is easy and ideal for those with smaller estates. As a part of the community counseling program, I draft many wills. A lot of the people, I'm working in Southeast Queens with Speaker Adams, a lot of people have smaller estates, not a whole lot of cash, but they want to feel secure in what they do have to give and pass to constituents. A lot of times they are real estate owners, homeowners, co-op owners, maybe minimal cash. You know, a will is best for them. A lot of times, a trust is ideal for those who have a high net worth, okay? Now, anybody have an idea why you think that is? Why would a person with a high net worth, depending on what high is, would want to avoid a will? Yeah, that's a good point. Anybody else? Mm-hmm. Well, that's always avoiding taxes, which you can't. A will can be contested. Yes, it can. Anybody else on what is it asking? Why a person would want to trust? With a person with a high net worth want to trust? Any other ideas? All right answers in the back. Can a trust be contested? It's very hard to do that because it's a private drafted document. It's possible, but not as easy as it's easier to contest a will. Yes.
Also, if you have a lot of money, you have a lot of money saved overseas, you kind of hide it in trust.
Okay. That's another novel idea. The other reason too, guess what? If you have a high net worth, you do a will. What happens to a will? What has to happen to a will when a person dies? Probate. You got an expert in the front here. Probate, right? Probate is expensive. The higher the estate, the more fees. And someone talks about contesting a will, more legal fees. Cases drag on for years, literally. Drags on, and attorneys get fees and fees and fees. And the court's like, why don't you settle this case? The court's favorite word is settle, if you haven't been to court. If you say settle to a judge, you make him or her smile, okay? And most judges say, a good settlement is when both parties leave a little bit unhappy, okay? But the main thing, too, a trust avoids probate. No one wants to go through all that. No one, stop it. No one wants to go through all that. A trust is almost like a contract, right? Next slide. Again, this running theme, I can't get away from it, folks. What if I don't execute a will or a trust? Here's the state, New York State's favorite estate plan. It's a favorite because it's the only one. So, Estate Powers and Trust Law 4-1.1, it's not all of it at the space, but it's order of priority, kind of like the Family Health Care Act. When someone has to step in, you don't do a health care proxy. These are the people that the state says, you don't have a estate plan? No problem. I'll say what happens to your estate. There's a lot of presumptions in here. Think about it, right? Okay, if decedent, you or me, survived by spouse and issues a fancy word for children, $50,000 and one half of the residue, one half of the leftovers after you take away 50 to the spouse, and the balance thereof to issue by representation. What does that mean? We're not getting to by representation. That's a way to distribute assets. That's a logical distribution chain. But it's basically $50,000 and one half to the spouse, balance to your kids. But wait a minute, Keith, I got a divorce, or I'm sorry, no disrespect, I don't like my spouse, or what? It's like, wait a minute, there's a lot of presumptions in here. So do you see, if you haven't seen already, why it's important, seriously, to make your own estate plan? Because you won't get away from this. This is it, right? Next one, spouse, if you die with spouse and no kids, hold to the spouse. Now, interesting enough, in a will, unless you have a court adjudicated separation agreement or a divorce, you can't disinherit a spouse. Not happening. Yes. 5 minutes? Okay, I'm almost done. Thank you. You can't disinherit a spouse, right? So they have something called elective share. They get 2/3 in the net estate. And so here, if you don't do a will, spouse gets the whole thing, right? If you're not divorced, right? 3, issue and no spouse. If you die with no kids, no spouse, kids and no spouse, all of it to your kids by representation. If you die with just one or both parents and no spouse and no kids, the whole to the surviving parent or parents. Then if you just die with issue of parents, that means their issue of parents, your brother or sister, no spouse, no issue, no kids of your own, or parent, the whole to your brothers or sisters, your siblings, by representation. After that goes down the line, eventually it cheats, they call it, it goes to New York State. They can't find a relative closer than your first cousin once removed, it will go to the state. Next slide, please. All right, last, I'm going to finish up record keeping. This is the attic in that state planning house, okay? You might want to start this now. My wife is from New York, I'm from Jersey. There was a book that New York would give you. I have to find that out again. She had an old copy. You write down your funeral information, your address, where you have your bank information, how you want your funeral done. You keep it in a book. I recommend getting something like that. A lot of websites or funeral homes have that kind of form as well. Keep it in a safe place. You might want to keep it in a fire-safe box or in a file cabinet, somewhere safe where you only know where that is and your loved ones know where that is. We need to let our loved ones ideally know if you want them to serve as executor in your estate plan or your power of attorney, but especially as the executor because you won't be there to see them perform, let them know beforehand, right? Keep estate documents in a safe place so our loved ones can find them, especially once you do them. Most attorneys have a vault. They will hold them in there. I don't know about Manhattan Surrogates Court. I think all the surrogates court in the city, they have a room where once the will is done, your attorney, or you can go down there. It might be a small fee, I'm not sure. You could file it in their vault. They'll keep it for you. Not a bad idea either. Why not that court have it? Don't worry about your attorney losing it or things like that. But most attorneys have a vault or a safe box to keep it in. But we have to keep good records for our family, history, finances, so it'll be easier for our family to access when we pass away. For the next slide. Lastly, I want to say thank you all for coming. I appreciate each and every one of you, and I hope that this was informative for you.